In essence, USDA wants to know, once and for all, just who and how much money it has to pay out. In other words, it's asking for a final accounting, as it were, and to allow the door to its financial books to be closed on discrimination, which it was found guilty of. Now, BIFA has filed a supplemental motion to intervene. Remember, BIFA has been telling its members all along that it had filed a motion to intervene on behalf of its members. Therefore, a couple of days after USDA filed its motion to terminate, BIFA filed its motion asking the court not to allow USDA to be able to terminate the tolling of the statute of limitation. BIFA Inc. will, however, be the first to acknowledge that invariably all things have to come to an end, and that the sun and the moon, as it were, should indeed be allowed to return to its normal cycle of rotations. And we further recognize that the day will come that the termination of the tolling of the statute of limitation should be allowed. However, BIFA Inc. believes that USDA has not acted in good faith, and therefore the tolling should continue until such time that USDA and its misconduct has been itself, to use USDA's own phrase, terminated and stopped. Moreover, BIFA Inc. believes that the legal concept of equity should bar the door open until certain equal protection violations being committed by USDA have been terminated. We have argued all along that USDA was violating the Constitution by allowing different lawsuits and different settlement agreements to be filed by different ethnic groups. That separate is still inherently unequal. USDA has a bus for African Americans. It has a lawsuit for Hispanic Americans. They have a water fountain for Native Americans. And there is a school for women. BIFA Inc. is arguing that these varying agreements with these other minority and all of the minority groups will invariably deprive members of the African American community of the same relief that other minority farmers and their heirs will receive. For instance, African Americans in Pickford 1 were denied relief because they failed to name a specifically identified, similarly situated white farmer. However, Native Americans, Hispanic Americans, and other claimants are not required to name a white farmer in order for them to be paid. Thousands of African Americans were denied the $50,000 for not being able to provide the white farmer information. Additionally, Pickford 2 claimants are denied access to injunctive relief. Injunctive relief is the money and credit to allow an individual to reestablish themselves or him or herself and in business or back in agriculture. This amount of money could range from anywhere from $600,000 to several million dollars per claimant. Moreover, USDA will not be able to use the claimant's credit history to deny them this relief. This injunctive relief money can be used to help economic development in the overall African American community, both in the rural and in the urban areas. This relief is being offered for all of the other minority farming communities except the African American farming community. Another issue that BIFA has with USDA receiving a termination of the tolling of the statute of limitation is that USDA never provided an opportunity for an individual who was discriminated against in a housing loan transaction to file a discrimination claim against it. When Congress passed or told the statutes of limitation to allow the farmers and their heirs to sue USDA in 1998, it expressly stated that a person could file a claim if they were discriminated against by USDA or its Rural Development Agency. As you will be able to see on the screen of pages 30 and 31 of Public Law 105-277, or Section 741, particularly subsection E, paragraph 1B, where it talks about housing loans discrimination. If these constitutional violations by USDA are not enough, consider the following. USDA is now brazenly saying, to everyone's shock and amazement, that no African American males will be allowed to participate in the Hispanic and women farmers' claims process. This is a stunning violation and a profound violation of the Constitution. But absolutely no other civil rights organization is speaking out against this position of apartheid and Jim Crow maneuver by USDA but BIFA Inc. Lastly, in Pickford 2, USDA created what is called a Cypre Beneficiary Fund. This Cypre Beneficiary Fund has been set up to place the funds for which a deceased or incapacitated claimant's estate will be deposited until a probate court determines that the submitter of the claim can prove that he or she is the lawful beneficiary to the deceased person's estate. This was not done in Pickford 1. Recall again, if you will, on pages 1 and 2 of the claim form, where it is asking you, are you the lawful representative of an incapacitated person's estate? What that means is that if you are the submitter or the heir filing a claim on behalf of a deceased person who died without a will, or an incapacitated person who has not established an estate, you will have 1 year after the claim has been approved to prove that you are the rightful beneficiary. If after the 1 year period, a probate court has not determined that you are the rightful beneficiary, the $50,000 settlement will go into this Cypre beneficiary account. This Cypre beneficiary account could be some organization in Montana, Oregon, Minnesota, or any other state. Here again, BIFA believes that this is a fundamental and unconstitutional act of taking. It is highway robbery, and it is taking money from the African American community and giving it to a community which the claimant was not from. Thousands of African Americans die intestate. Therefore, hundreds of millions of dollars could be transferred out of the very community where its members, the victims of having been denied loans and credit benefits. In sum, these are just some of the issues that we will be raising in our argument as to why USDA should not, for now at least, be allowed the benefit of having the tolling of the statute of limitations terminated. Termination should not be granted until all of the claimants who have filed claims during the period of the tolling have had a full measure of justice from these proceedings, which are for the protection of person and property as is enjoyed by white citizens. This is a fundamental right, and a treaty that this country made to the African American community when slavery ended. Members of our community deserve the right to have had a wholesome opportunity to make a meritorious claim of discrimination, free from misconduct by USDA that made the tolling of the statute of limitation necessary